Got a secret, can you keep it? Swear this one you save. Better lock it in your pocket, taking this one to the grave. If I show you, then I know you won't tell what I said. 'Cause two can keep a secret if one of them is dead.
The privacy of communication and correspondence shall be inviolable,
except upon lawful order of the court, or when public safety or order requires otherwise, as prescribed by law.
Any evidence obtained in violation of this or the preceding chapter shall be inadmissible for any purpose in any proceeding.
Oh my gosh, I can't I have a team.
Oh my god.
So there's this 24-year-old guy who's working at the canteen. And then he met this dude who is 14 years old when this dude told that he had a crush on, exchange messages, something like that. And then the girl accepted the friend request.
Okay.
They became sweethearts in April 2016.
The right to privacy is invaded by whom? This is the question that needs to be answered. Here, the right to privacy was invaded primarily by the aggrieved party, not the state.
I don't know what happened.
Although the accused contended that his right was violated because of the unlawful acquisition of the evidence against him, the court ruled that the photographs and conversations in the Facebook Messenger account, which he considers as the fruit of the poisonous tree, were not obtained through the efforts of the police officers or any agents of the state.
Like literally know about the relationship, right? The mother learned about the relationship, and then they did just ignore the warning of the mother, and then they just
Of course, the
went
mother
on
was
with their
forced to break up with the guy. Something like that.
Is that all? No.
Here's an actual news clip.
Dito sa kaso po na pinag-uusapan ho natin, itong People versus Kadahas, diniscuss po ng Supreme Court po talaga yung puntong paggamit ng mga Facebook conversation or mga pictures in relation to the constitutional right to privacy.
Had it not been for the discovery of the occurrence of such conversations, the accused would still be free until now. Privacy is a right, one that must be upheld and protected at all costs. It helps establish boundaries to limit who has access to our bodies, places, and things, as well as our information and our communication.
Like the girl.
No way, you gotta be kidding me.
Naked. The guy was asking for naked photos. Like,
And in the case of Ejercito versus Sandigan Bayan, the fruit of the poisonous tree was defined. It was simply put that once the primary source or the tree is shown to have been unlawfully obtained, the secondary or the derivative evidence or the fruit is also inadmissible.
Oh my!
Got a secret, can you keep it? Swear this one you save. Better lock it in your pocket, taking this one to the grave. If I show you, then I know you won't tell what I said. 'Cause two can keep a secret if one of them is dead.
The privacy of communication and correspondence shall be inviolable,
Except upon lawful order of the court, or when public safety or order requires otherwise, as prescribed by law.
Any evidence obtained in violation of this or the preceding chapter shall be inadmissible for any purpose in any proceeding.
hi Gary. Hello baby, how are you? Yeah? Yeah, I'm with my cozy two groupmates right now. Why? Are you okay? Oh, you want to talk about last Friday night? Oh my goodness. You know what, baby? It's really funny because, we maxed out our credit cards, so we got kicked out of the bar, and then we hit the boulevard last Friday night. What do you mean, baby? Oh, Cardo? Oh, Cardo de Lisa, my classmate? No, baby. He wasn't there. He wasn't with me. What? No, that's not right. We were not eating together. Baby, what are you talking about? Oh, no, baby. Come on. Oh, my. Let's talk this out, baby. You thought it all wrong. No, we can't work it. Hello? Hello, Gary?
I remember when Karen was heartbroken and Saul accidentally tapped her phone and overheard everything, which is funny because at that time we were law students. Anti-wiretapping law, or RA 4200, states that it is unlawful for any person not being authorized by all parties to any private communication or spoken word to tap any wire or cable, or by using any telecommunications device to secretly overhear, intercept, or record such communications.
Damn! What? I tapped Karen's phone.
Oh my God, so?
Yes, here's what I heard.
What?
Gary broke up with Karen.
Wait, what? Gary?
Yes, he did.
What happened?
Guess why?
What?
Karen cheated.
Karen cheated?
And guess who? Karen cheated with Cardo.
Cardo? Cardo who?
Cardo de Lisa!
No! Karen is
Yes, me too. I can't imagine, but well, those guys.
No.
That's it.
Oh my gosh. Saul! Karen's gonna kill you for tapping into her phone.
Oh my gosh. I didn't see that coming.
Oh my gosh. You did?
She will?
I
For tapping your
phone? Yeah, because you can't tap anyone's phone. Not even Karen's. Not even a cheater's phone.
But they're cheaters.
I hate cheaters.
Me too.
Cheaters go to hell.
They do?
Yeah.
Yes, I found out. Even the possession of any record, whether contained in a tape, wire, or disc, and any copies thereof, in a manner prohibited by law, the replay of such recordings to other persons, or to communicate its contents, verbally or in writing, is also not allowed.
I cannot believe Karen cheated.
Except only when such recordings are to be used as pieces of evidence in any civil, criminal investigations, or trial of offenses. They may be permissible or allowed by the law.
Everything for her.
I know.
Oh my gosh.
Is that Karen?
Yeah. Should I pick up?
You should pick it up. Go
my
ahead.
God. Hello, Karen. Sorry. Yeah.
We know.
Got a secret, can you keep it? Swear this one you save. Better lock it in your pocket, taking this one to the grave. If I show you, then I know you won't tell what I said. 'Cause two can keep a secret if one of them is dead.
The privacy of communication and correspondence shall be inviolable,
Except upon lawful order of the court, or when public safety or order requires otherwise, as prescribed by law.
Any evidence obtained in violation of this or the preceding chapter shall be inadmissible for any purpose in any proceeding. I remember a similar case as to what happened in Vivares versus St. Teresa's College. Nenita Dalos and Julien Suzara, both minors at that time, also graduating students of St. Teresa's College in Cebu City, in January 2012, while changing into their swimsuits for a beach party they were going to attend, Julia and Julien, along with several others, took digital pictures of themselves clad only in their undergarments or their bikinis. These photos were then uploaded by Angela Tan on her Facebook profile. Now back at school, Mylene Reza Escudero, a computer teacher of STC, learned from the senior students that some posted photos online depicting themselves from the waist up, clad only in brassieres. Now, they asked who those students were, and they were readily identified as Julia, Julienne, and Chloe, amongst others.
Escudero's students claimed that there were times when the access to or the availability of the identified students' photos was not confined into the girls' Facebook friends, but were, in fact, viewable by any Facebook users. Thereafter, following an investigation, the school found the identified students to have deported themselves in a manner prescribed by the school's student handbook.
On March 25, 2012, petitioner Wanda Vivares, the mother of Julia, joined the fray as an intervener. That same day, the RTC issued a temporary restraining order allowing the students to attend the graduation ceremony, to which STC filed a motion for reconsideration. Despite the issuance of the TRO, STC nevertheless barred and sanctioned students from participating in the graduation rites, arguing that on the date of the commencement exercises, its adverted motion for reconsideration on the issuance of the TRO remained unresolved. Thereafter, petitioners filed before the RTC a petition for the issuance of a writ of habeas data on the basis of the following considerations.
First, the photos of their children in their undergarments. Second, the privacy setting of their children's Facebook accounts was set as friends only. Third, respondents being involved in the field of education knew or ought to have known of laws that safeguard the right to privacy. Fourth, the photos' access belonged to the girls and thus cannot be used and reproduced without their consent. Fifth, the intrusion into the Facebook accounts as well as the copying of the information, data, digital images happened at the school's computer laboratory. Number 6, to petitioners, in the interplay of the foregoing constitutes an invasion of their children's privacy.
Oh my gosh! I'm so drunk! I'm so drunk! We're so drunk! This is so good. Very
In the landmark case of Vivares versus STC, writ of habeas data is defined as the remedy available to any person whose right to privacy in life, right to privacy in liberty, or security is violated or threatened by any unlawful act or omission of a public official or employee or of a private entity, private individual, or entity engaged in the gathering, collection, or sorting of data or information regarding the person, family, home, and correspondence of the aggrieved party in order to achieve unlawful ends. Take note of that, in order to achieve unlawful ends.
In this case, the Supreme Court held that the petition of the aggrieved party's parents, the writ of habeas data, is denied. The teachers, who were also considered as public employees, were mere recipients of what were posted, and by obtaining the photographs of the students, they did not resort to any unlawful means of gathering the information, as it was voluntarily given to them by persons who had legitimate access to the said post. The fact that the said photographs were uploaded by the student through a mainstream social media application called Facebook, where default audience setting is friends only, it makes it available for public consumption.
Furthermore, petitioners failed to prove their contention that respondents reproduced and broadcasted the photographs. these are not tantamount to a violation of the minor's informational privacy rights. Contrary to petitioner's assertion, without proof that they placed the photographs subject of this case within the ambit of their protected zone of privacy, they cannot now insist that they have an expectation of privacy with respect to the photographs in question.